Fitzgerald.
Thank you, Chairman. Professor Contreras, I introduced a bill, the Prohibiting Adversarial Patents Act. What we were trying to get at is it would prohibit companies on certain national security-related sanctions lists from licensing or asserting their U.S. patents, much as we discussed here this afternoon. To your knowledge, are adversaries like China using forums like ITC to assert U.S. patents that generate revenue in circumvention of U.S. sanctions?
Congressman, I'm not aware of any concerted effort by the Chinese government in that respect. Certainly, companies from many different countries are able to utilize the ITC against U.S. companies and against other foreign companies if they do so through their U.S. subsidiaries, which almost every foreign company of any size has today, which does make the ITC a forum available to foreign companies controlled by whoever to take advantage of U.S. manufacturers.
Right, and I don't think we're concerned about some of our friends, but adversaries like China using patent assertion entities to bring infringement suits that generate revenue in circumvention of U.S. sanctions. So, is there anybody out there that they've already demonstrated that they are moving in that direction, I guess, is maybe a broader way of asking the question. Do you see any of this activity?
I'm not aware of the I'm not aware of a specific national security type of circumvention that's going on at the ITC. My other co-panelists maybe.
Okay, Mr. Corte, please explain kind of briefly how ITC rules of procedure differ from U.S. district courts and why they often lead to higher costs for litigation, right?
Yes, thank you, Congressman, for the question. So there's, I think, two main areas where ITC procedure drives up cost. First, in U.S. district court judges often manage their docket through motion practice, motion to dismisses, summary judgment motions. These motions before a trial often resolve the case or lead to a settlement. Right. At the ITC, typically in a hearing, none of these motions are decided until the morning before the trial. So very few ITC investigations settle before the trial. The ITC noticed this in their last budget request, that they have increased workload because almost no ITC 337 investigations are settling. That drives up cost because every case is going to trial. The second main way that ITC cases drive up costs is the exclusion order. If you are a company either making a product in the United States or importing a product, you have to prepare in advance for that exclusion order in the event that you lose by designing your products, by changing your product supply lines, by changing your inventory levels. That all adds incredible cost on top of the standard cost we would face in a parallel lawsuit in federal district court.
Yeah, so ITC litigation, kind of the costs associated with it, which is probably difficult to put a hard number on, but I mean, there's so many different steps in that suit that you're engaged on a regular basis. I'm sure the bills are just astronomical after a while for somebody involved in this, right?
Yes, I mean, there are multiples, 2, 3, 4 times the cost of a patent lawsuit in federal court, where those lawsuits are already one of the most expensive activities on earth. So it's, in some years, our ITC investigation defense costs are by far the biggest line item on our legal budget globally.
Just real quick, Professor Contreras, when an entity brings a complaint to the ITC under Section 337, are they required, do they have to disclose who is funding that complaint? Is that something that's disclosed along the way?
No, they don't. There's a lot of ambiguity around who is behind some of these entities, many of which are names that you wouldn't recognize at all. They're possibly sole purpose is bringing these actions.
And because of the lack of disclosure, there's some risks there, right? I'm sure.
Absolutely, absolutely. It could go back to the question that you asked previously. It could be a pure corporate maneuver. It could be a governmental maneuver. We just don't know.
Yeah. Thank you. I yield back, Chairman.
Thank the gentleman. We now go to the gentlelady from North Carolina, Ms. Ross.
Thank you, Mr. Chair.